Welcome to Cutler Legal, Basic Law. Today we're going to talk about res judicata. Apologize, talking Latin, but sometimes I have to do it. It's an old concept in the law, but a very sound and important concept. It essentially means the court will not allow a party to relitigate the same matter over and over again. And when I say matter, what I'm really saying is the same underlying facts. The court will not allow a party to go back to court and argue different legal theories based on the same facts in separate lawsuits. You have to bring all your legal theories regarding a particular set of facts in one lawsuit. For example, let's say it was a partner dispute over technology development, and one partner was accused of stealing the technology from another partner. And the partner who felt wrong brought the lawsuit. And the legal claims he could bring would be breach of partnership agreement, fraud, misrepresentation, theft of trade secrets, and fiduciary duty. Let's say that person brought all those claims but fiduciary duty, and for whatever reason lost. And then said, well, I want another bite of the apple. I want to go back to court. I didn't argue fiduciary duty. I think that's really what was the proper claim. And go back to court, bring another lawsuit, maybe in a different court. The defendant could say, no, you've waived that claim. You've waived the opportunity to do that. You should have raised fiduciary duty in your first lawsuit because you're asserting the same facts, the same circumstances, but you're just pursuing a different legal theory. And under that circumstance, the courts would agree with the defendant and bar you from pursuing that claim. When can you raise res judicata? You raise it in your answer. You raise it as an affirmative defense, something you as defendant must show. You must show that, one, these same facts were litigated in a separate lawsuit, identify what that lawsuit is, and they were resolved in that lawsuit, and therefore the defendant should be barred from reasserting them in the present lawsuit. Then you can bring a motion to dismiss the action. You can either bring a motion to dismiss or a summary judgment, or both in timing orders. Motion to dismiss at the beginning of the suit. If you lose that, you bring it later at summary judgment, and then you can assert it at the time of trial. And it really is a concept of finality, fairness, and economy. We don't want people constantly going back to court and being a dog with a bone and keep fighting the same thing over and over again. We'll give you the chance, bring your claims, fight it out, and live with the results. Thank you. Hope it made sense.